Both sides are pretty entrenched. On the one side, with every bit of rights is property rights folks who say, this is my property, I should be able to do with it what I want, I bought it in good faith, etc., etc. On the other side, you have those that say, no, for the better good. Now, in 1973, the Senate, the Oregon Senate, passed Senate Bill 100. Okay, what that did, and that was the outgrowth of actually seed growers in the Willamette Valley. One particular very powerful senator at the time, state senator. What that did is effectively put a template on the entire state, and with a bunch of goals that affects land use, and it's supposed to take into account the environment, the economy, etc. There's 14 of them, maybe more than 14 now, because it gets added to. That's Senate Bill 100. That is the law of the land, of the state of Oregon anyway. And we, as county government, has to adhere to that. Now, I know you're going to hear arguments one way or another, but the definition of a county in the state of Oregon is that we are parts, we're the boots on the ground, if you will, is one of my favorite expressions of state government, whether we like it or not. That's the way it's set up. And so we, as much as one would like to say, now again, you can get arguments on both sides, and I probably shouldn't be going on so long, I should let you talk, because I know there's people here that want to talk about this. But on one hand, you have those that say, let me do what I want to do, and the others say, no, I love where I'm at. I moved away from someplace to come here. Okay, well, I could take the Tom McCall stance and say, well, that's good, drop your money and head back south. You know, but that's not right. But the point being is that people have found their paradise here, and this is paradise, and they don't want anything to happen to it. We have people, I was raised in Ashland for the better part of my life, okay, and in the 50s, and the valley looks a lot different than when I was a teenager in the 50s, okay, but that's people, that's inward migration, whatever the case, and so you have folks that lived here a long time, don't want anybody messing with their property, and you got, so it's again, and I'm going to open this up. I'm not going to turn it into a forum, okay? But I know that people here have got opinions on this. I'm going to give you some time to talk about it, but then I'm going to shut it down after a while. So, fire away.
Can I clarify? Were you just saying the type of government we were? We're a part of the state government?
We're actually a servant of state government. That's what counties are. That's what counties are.
Why do we need commissioners?
Pardon me?
Why
you
do
want
we
to be
need
ruled
commissioners?
Vote us out.
So you don't believe in the third level of sovereignty?
No, I don't. Not at the county level. No, we're a home rule county, okay, which gives us, there's 9 home rule counties out of 36. The rest of them are general law counties. What definition? General law counties are those counties that they are actually basically their election laws and are all set out of Salem. Okay, home rule, which was enacted by the voters, gives us a little bit of leeway, so we can choose on how many commissioners we want, how long their term is. I'm just talking about commissioners. A lot of things one can do, but we have certain rights when it comes to government. I've been asked the question: if Josephine or Curry County goes belly up, does that mean the state can force Jackson County, who from a financial standpoint is in great shape, to take on their debts? No, they can't, because we're home rule county. Okay, so we don't have to do that. So that's that part. However, state law is state law, and as much as we want to say, boy, I'd love to be able to do it here, I want local control, by gosh, and I know that's a passionate thing. You just can't think of it because ultimately that's the law, and you'll end up paying for it one way or another. Yes, sir.
One of the biggest threats is SB 100. Would you agree with that?
Pardon me?
In terms of property rights, SB 100 is one of the biggest threats.
I would love to see SB 100 repealed.
So I was wondering if you could give us an update on the coordination resolution that was passed in December, and how you see that fit in with what you just shared about the county being a
the
servant
coordination doesn't have anything to do with
to the state capital.
Okay, it has to do with federal agencies. For those who aren't familiar with coordination, okay, it's a federal law. It deals more stringently with BLM than it does with Forest Service. It has to do with land use as it pertains to to government-owned lands contiguous to publicly owned lands. And what it says very simply is before the feds can do something, especially BLM, more so than the Forest Service, before they do anything, they have to notify us. They have to say, they have to send us a letter and say, this is what we're going to do, yada, 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 whatever it is, okay? So what that means is then we have the opportunity then to pick up the phone, whatever the case, and say, hey, we'd like to talk to you about it, because we think it may have adverse effects on something that has to do with the county, either our citizens or the land or whatever the case may be, okay? Now, you're going to hear people argue that the federal government then has to listen. They have to listen, but they don't have to do anything about it. Now, you're going to hear people, like I say, are going to say, no, that's the case. You know, that isn't going to happen. I'm just telling you that at least we have them coming to the table. And an answer to your question, Kevin, is that since we sent out the coordination, I've only been in office for 16 months, so I don't have a big history. A lot I've talked to C.W. Smith, who's been here he's finishing his 8th year. They never sent, they being either the BLM or the federal, and it's not just them, it has to do with DEQ and the other federal agencies, but it has to do with land, it has to do with land use. Unless somebody had a personal relationship with one of the department or heads or one of the region managers or something, we never heard anything until after the fact was being done and we read about it in the Tribune, or probably if we really had a good paper, the Jacksonville Review. That's how we found out about it. I will say, since that December, I usually get on an average of 2 to 3 letters from one of the federal agencies. A lot of times it comes to me because I'm the chair, but a lot of times it comes to we copy all 3 commissioners, regardless if it's addressed to me or not. And from whatever federal agency, BLM is going to have road closures up here and the small spur road closures up here, and sort of. That then, what we do is we take that information and we divide it. There's 32 federal agencies that we sent letters out, our coordination. Sent them our ordinance, sent it off to every one of them, and a lot of them went back to D.C. A lot of them went right to the secretary. A lot of them went to Portland, to Salem, Colorado, wherever their head person was. And then we took those 32 federal agencies and we divvied them up amongst the 3 of us. And said, okay, guys, this is your responsibility. Make sure you follow up on coordination. So once we are coordinated, then you've got to make sure you respond. And proactively, for those that we want to reach out on the telephone if they'll take our phone call, if it's the secretary, but sometimes they do. But at least try to reach out, besides just the letter, reach out, introduce ourselves. If you're in the area, we'd love to talk to you. If I'm up to Portland, I'd like to talk to in fact, my building relationship now with the Corps guy out of Portland, Corps of Engineers guy. When I'm up there, he's invited me to come to the office. The point being is develop a relationship. So even though we can't dictate, and I know people feel differently, we can't dictate what the government's going to do, at least talk to us about. Maybe we have some impact, and maybe we won't, but at least it's better than we ever had before. Now, better, does that mean, well, has anything changed? Well, most of it not, to be real honest with you, but incremental steps.
So what did the letters say?
Which one?
The ones that you sent to the federal agency?
Well, it's a public record. I'm glad to send it to you. What we did is we talked about the coordination process. The way we understand it is we send them a copy of our ordinance, asking to make sure that they coordinate with us. We only had one, interestingly. We did have one, and I'm trying to remember the federal agency that sent a letter back. It was typical blah, 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 blah stuff. But they said, no, we don't have to because federal law trumps your ordinance. So we had counsel draft a letter responding to the agency saying, based on the law, on the coordination law, that's not true. So that's where that's at. I mean, we haven't heard any response back from them. But my point being is that we're not just saying, okay. I mean, that's a real simple, quick, and I know it's in so much more depth. I mean, you know, attorneys are making a lot of money on both sides on that issue. I wish, you know, I wish there was a way that we could rectify that. People that are a heck of a lot smarter than I am
Measure
are working on
15,
that.
111.
Okay,
By that.
well, okay, all right, you've asked a fair question. Okay, I'll answer that question, all right? I came out against it, and I'll tell you why. Okay, 110 is a suggestion. 110 is basically saying, and you can correct me if I'm wrong, but I think if you read the ballot measure, it's saying, we disagree with state land use laws, and we think as a people of Jackson County, we can do with what we want to do with our land. Simply put. Doesn't give any absolutes. It says, we're telling you, state of Oregon,
Policy.
that we think, you know, in effect, we're just thumbing our nose at them, okay? 111, that's 110, excuse me. 111, on the other hand, actually carries that a little bit further. It actually goes back and tries to resurrect 37. So it goes back and it says, okay, under Measure 37, we feel that we're due either just compensation for the value of our land, or you allow us to do with what we want to do. Forgetting Measure 49 completely. Unfortunately, 49 trumps 37, 49 is the law of the land. So the reason why I came out against it, philosophically, I got to tell you, I'm on your side 100%. Practically, however, there's just no way that can get done. We can say that. We can thumb our nose. Let me finish. Okay. We can thumb our nose all we want to, and we can pontificate and beat our chest, and I don't mean to be disrespectful or anything on this, all we want. But what's going to happen is that if, in fact, those ordinances get passed, one is benign. I mean, well, 110. 111, however, because it'll have an ordinance that goes along with it. So people are going to have that false expectation of saying, okay, I'm getting my claims in, I'm getting my claims in. They're going to have false expectation because we have to provide an ordinance because it would be voted on. Then we have to defend that. And the state's going to slap us down. It's going to cost us a lot of money. It will not pass. It will not pass the muster of law.
Well, there's two halves of that, and there's the severability. The first
I
half is going
understand that.
forward. The other half is honoring those waivers that were already ratified by prior boards of commissioners. And that, to me, is keeping the county keeping its word to those people.
Yeah,
So
well,
why would you be against that?
just 49 did away with that.
But those were approved before.
Because,
Measure
but there was a
49
set of
passed.
conditions that they had to make. Again, this is prior to my time, but I'm not just saying, so I don't care. It's done before me, so that's,
Yeah.
don't blame me. I'm taking responsibility for that because we've looked at that, I've looked at that, I've talked to council, I've talked to another land use attorney that is not a county council. How does this work? Would this possibly work? Because, like I said, I think there was only 6 or 9, can help me if
There
I'm
were
the number,
600.
that
were
perfected,
approved.
right,
Yeah.
okay. Other than that, they didn't get the paperwork, I guess, in, so,
No, but there were a large number that had approved waivers that were ratified by the board. So that's what that half of the bill is about. So I don't understand why you wouldn't want to say, yeah, we want to honor those. It wouldn't cost the county money to honor them. You know?
let's look at that.
All it does is allow the use.
Okay, I'll look at that. Okay, thank you.
Just to follow up on that question, would the measures trump 49 on a county level?
No,
Is that what council says?
state, yeah, that's right, that's state law. County law never trumps state law,
Never.
never.
But 49 never addressed claims that were already approved.
No, but what it's doing is it's saying that we don't care what 49 says. We're doing it our way. Okay? Go ahead, Kurt.
One thing, Don, that we got to get off the bill when we're talking about what trumps this, what trumps that, is the forgotten trump, is the Constitution. And it trumps all laws if they're repugnant to the Constitution. So that might be a good place for us to start looking at some of our laws.
I understand, and you've done a nice job of keeping that in front of me. No, I mean that, I say that in respect.
Well,
Okay.
it's supposed to be the law of the land,
Okay.
not the statutes.
Okay. Okay.